In 1868, Congress ratified the 14th Amendment, signing into law a document that would wind up at the center of race relations for the next 100 years. Some of America's most famous Supreme Court cases involve the 14th Amendment, including Plessy versus Ferguson and Brown versus Board of Education. In the next hour, we'll take a look at the way the Supreme Court's decisions influenced the 14th Amendment and how, in turn, it influenced America. This is Cases in Controversy. Brown versus Board of Education was actually an amalgamation or combination of several court cases from around the country. Brown versus Board of Education from Kansas, Briggs versus Elliott from South Carolina, Davis versus County School Board of Prince Edward County from Virginia, and Gephardt versus Belton from Delaware. For simplicity's sake, the Supreme Court chose to rule on all cases concurrently. This had the added benefit of making clear the government's position. Segregation isn't acceptable in any state.
Today, education is perhaps the most important function of state and local governments. It is the very foundation of good citizenship. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal.
Brown versus Board of Education was the case that finally said that separate but equal is inherently unequal.
It overturned the system of education in this country, particularly in the South and what we call border states, such as Missouri.
It's really the case that that put the death knell to Jim Crow segregation as a legal institution.
Those who strategized were looking for a Brown decision that would ultimately say that separate was inherently unequal.
Brown was written as an education case, but very promptly the Supreme Court held that separate swimming pools, separate water fountains, separate golf courses imposed by government were all unconstitutional.